Hello, everyone, and welcome to the Federalist Society virtual event. My name is Edith Harold, and I'm an Assistant Director of Practice Groups with the Federalist Society. Today, we're excited to host this FedSoc Forum called Can the Federal Government Ban At-Home Distilling? Speaking with us today, we have Thomas Berry, Michael Pepson, and Professor Eric Siegel. Moderating the discussion, we have Ted Cooperstein, who is an appellate counsel of Theodore Cooperstein PLLC. If you'd like to learn more about today's moderator or speakers, their full bios can be viewed on our website, fedsoc.org. Throughout the program, we may turn to the audience for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we will do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers and not the Federalist Society. With that, Ted, thanks so much for joining us today, and I'll hand things over to you.
Thank you, Edie. I'll briefly introduce our speakers in the order that they've chosen amongst themselves to present today. And with that, we'll then proceed. Our first speaker is Michael Pepson, who's a regulatory counsel at Americans for Prosperity Foundation, which frequently files amicus briefs in the U.S. Supreme Court, U.S. Courts of Appeals, and state Supreme Courts, as well as public comments in various federal and state regulatory proceedings. Mike assists AFPF with its efforts involving separation of powers, administrative process, criminal justice reform, tech and innovation, and other issues. He is also special counsel for administrative law at Cause of Action Institute, where he's been involved in complex civil and criminal litigation in federal district and appellate courts and administrative litigation before federal agencies in a variety of matters, including agency enforcement actions, statutory and constitutional challenges to federal regulations and agency decisions, and Section 1983 challenges to state statutes. He received his LLM from Columbia Law School, JD from the Catholic University of America, Columbus School of Law, and BA from Loyola College in Baltimore, Maryland. Our next speaker is Professor Eric Siegel, who is Ashe Family Chair Professor of Law at Georgia State University College of Law. Eric Siegel graduated from Emory University, Phi Beta Kappa and Summa Cum Laude, and from Vanderbilt Law School, where he was the research editor for the Law Review and member of the Order of the Coif. He clerked for the Chief Judge Charles Moy Jr. for the Northern District of Georgia and Albert J. Henderson of the 11th Circuit Court of Appeals. After his clerkship, Siegel worked for Gibson, Dunn & Crutcher in the U.S. Department of Justice before joining the Georgia State faculty in 1991. Siegel teaches Federal Courts and Constitutional Law 1 and 2. He is the author of the books Originalism as Faith and Supreme Myths, Why the Supreme Court is Not a Court and Its Justices Are Not Judges. His review online, the UCLA Law Review, the George Washington Law Review, the Washington University Law Review, the University of Pennsylvania Journal of Constitutional Law, the Northwestern University Law Review Colloquy, and Constitutional Commentary, among many others. Siegel's op-eds and essays have appeared in the New York Times, the LA Times, the Atlantic, Slate, Vox, Salon, and the Daily Beast, among others. He has appeared on CNN, Fox News, MSNBC, and France 24, and all four of Atlanta's local television stations. He has also appeared on numerous local and national radio news. Our third speaker will be Thomas Berry, who is director of the Robert A. Levy Center for Constitutional Studies at the Cato Institute. He's also editor-in-chief of the Cato Supreme Court Review. Before joining Cato, he was an attorney at Pacific Legal Foundation and clerk for Judge E. Grady Jolly of the U.S. Court of Appeals for the Fifth Circuit. His academic work has appeared in NYU Journal of Law and Liberty, Washington and Lee Law Review Online, and Federalist Society Review. His popular writing has appeared in the Wall Street Journal, National Law Journal, Investors Business Daily, National Review Online, and The Hill Online. He has testified before the U.S. Senate, and his work has been cited by the U.S. District Court for the District of Columbia. Berry holds a JD from Stanford Law School, where he was a senior editor on the Stanford Law and Policy Review and a Bradley Student Fellow in the Stanford Constitutional Law Center. He graduated with a BA in Liberal Arts from St. John's College, Santa Fe. With that, I'll turn it over to Mike Pepson to begin. And Mike, perhaps you might want to just briefly state the issues in the case and then go ahead with your comments on it.
Absolutely. Edith, thank you very much for putting this together. Ted, thank you very much for your kind introduction. Thank you to the Federalist Society for allowing me to participate and for all that it does. In full disclosure, AFPF did file an amicus in support of plaintiffs appellees in this case. All errors and omissions mine. With that, the basic issue in this case is whether the federal government has the power to ban at-home distilling for personal use. The statute at issue was passed in 1868, so it's fairly old, but it's 100 years plus distant from when the Constitution was ratified. Plaintiffs, appellees challenged it as exceeding the federal government's powers under both the Commerce Clause and the taxing power, even as augmented by the Necessary and Proper Clause. The statute at issue notably has no jurisdictional hook reference to interstate commerce, nor does it reference revenue collection. The district court found that this statute, which the Commerce Clause has been deemed by the Supreme Court to allow regulation of three categories as supplemented by Necessary and Proper Clause. The channels of commerce, like highways, instrumentalities like cars and people moving in commerce, and then more recently in the New Deal era, to also encompass activities that substantially affect interstate commerce, including those that do so under the aggregation principle, which I would submit is questionable, under the tax. But the court found that the statute at issue regulated neither of the channels nor instrumentalities, assumed it regulated matters that in the aggregate affected interstate commerce, but nonetheless found that it exceeded federal authority because it was not part of a comprehensive scheme, and nor was it reasonably related to that scheme. The court also found, as to the taxing power, that the ban itself was not a tax because it was revenue or it frustrated revenue raising, since it was simply a ban, and nor could it be justified under the Necessary and Proper Clause because it was not plainly adapted to effectuating that enumerated power. The court, combined the PI motion with a, summary judgment, and the government has appealed. On appeal, the government does not challenge the Commerce Clause ruling, or appear to, and has now fallen back on the argument that the at-home distilling ban is justified as a necessary and proper because it's reasonably related to the collection of revenue, because at-home distilling frustrates that. I think at a broader level, this case implicates important questions of federalism and the division of authority between the federal and state government, which, as well as how one should interpret how the Constitution's original public meaning should play into constitutional interpretation, as many would suggest that the court's modern Commerce Clause precedent, including as it relates to the Necessary and Proper Clause, has expanded beyond what was intended, trade and transportation between states, to encompass matters of traditional state concerns, such as matters of health and safety and crime, which this at-home ban would reach. The same might hold true of the Necessary and Proper Clause, where the government has a very broad conception of it, taking language from United States v. Comstock to suggest that it's enough that there's a rational relationship, but there could be, between the tax and the revenue-raising feature, even if it's a kind of a ban and it covers activity that occurs before a taxable product is created, and likewise, perhaps as to the taxing power. And with that, I'll turn it over to Professor Siegel.
Thanks for having me. I'm always honored to be a guest in the Fellow Society House, especially given that my politics and yours don't agree. But I'm really happy to be here, and this is a great panel. So this law was passed 156 years ago. How that could make it more susceptible to an original meaning attack is beyond my comprehension. So listen, if this were 1982, when the Federalist Society began, I would be the chairman of honor. You guys would worship at my work. Because what I am here to say is this case does involve a very important issue, the role of judges. And the 1982 Federalist Society would never have taken the side of challenging this law because the 1982 Federalist Society wanted judges to be constrained. And so do I. I think Roe versus Wade was incorrectly decided, even though I am pro-choice all the way down. So on what possible basis could this law be struck down under the Commerce Clause? I agree that it is at the outer perimeter of Congress's authority. However, Justice Marshall described the Commerce Power in 1824 in great breadth, and he was there, he lived it, he knew. We can talk about living constitutionalism if you want, and Cato's desire to deregulate America. That we can talk about, but that's Cato's desire. Chief Justice John Marshall's desire was to keep judges out of economic decisions. There's no possible way the original meaning of the Commerce Clause does not justify this law. Now, living constitutionalism might. And if everyone thinks the Commerce Clause has gotten out of whack because now we have an interconnected international economy, whereas in 1791 we didn't, if you think that, that's fine. Just admit that you're living constitutionalists, admit that you're policymakers, and admit that you want judges to second guess Congress's decisions. That's all fine. But there's no text, there's no history, there's no precedent to support striking this down. And what I find fascinating is this absence of a jurisdictional hook. So everyone knows about the Lopez case, can't carry a gun around school, struck down. However, Congress amended the law to say you can't carry a gun around school that moved in commerce. 3 circuit courts upheld it, Supreme Court denied cert. In 18 whatever this law was passed, there was no need to pass a jurisdictional hook. Lopez wouldn't be decided for a century. So of course there's no jurisdictional hook in a statute 156 years old. But the fact that the statute was passed 156 years ago should give original meaning people some pause. You're saying you know more about the original meaning of the Constitution than the Congress from 156 years ago and from Chief Justice John Marshall. Neither of those two statements are credible. The reality is this. Over the last 35 years, Cato and Heritage and the Federalist Society has done a great job of pretending that the New Deal was a watershed moment in American history where all of a sudden the federal government became really big. Not true. The first Congress gave George Washington $1 million and said, spend it any way you want. The first Congress authorized tax people to go into the states from the federal government. There's always been delegation. There's always been broad regulations of commerce. So my only point is this. If you want to be an originalist, this case is easy. The law should be upheld. If you want to be a living constitutionalist, that's fine. You can make your policy arguments and say Congress shouldn't be doing this kind of thing. If one believes in, my last sentence is this, if one believes in the Federalist Society's pledge that judges should make the law, not should find the law, not make the law, which of course is a bunch of horse hockey. But if one believes in that, then there are 15 different ways at-home stills affect the commerce of more states than one, which is exactly what John Marshall said in 1819. So I'm glad everybody here who wants to strike this down thinks they know more about the original Commerce Clause than the Chief Justice of the United States writing in 1819, but I don't agree with that. I don't like this law. I think it's probably a stupid law. I agree with Justice Black in Griswold. I wouldn't vote for this law. It's an uncommonly silly law. But if you give judges the power to strike down this law, you're giving judges a tremendous amount of power, something I always thought the Federalist Society was against, but not over the last 20 years. Thank you very much.
All right, then. I guess it's time for Tom Berry.
All right. Well, thanks so much for having me. It's always an honor to speak on a Federalist Society webinar. And I actually completely agree with one aspect of Professor Siegel's history of FedSoc, which is, yes, if this case were 40 years ago, most FedSoc members probably would be against judges striking down laws. It's an important, and I think the big shift in what you might call the conservative libertarian legal movement, from what might be called judicial constraint to what I prefer to call judicial engagement, but others might call judicial activism. That's a fair debate to have. And I think it's a very good thing that sort of what started with those on the right just being reactive or reactionary against the Warren Court and thinking, oh, I don't like their decision striking down laws, so therefore, in general, I'm going to have a posture of extreme skepticism to judges striking down laws, has now shifted to a point where in my view, you should not have a thumb on the scale in either direction. You should neither have deference towards statutory law or towards judges striking down the law. You You should simply engage with the constitutional text and call it as you see it. And my colleague Clark Neely coined the term judicial engagement for that. And I think that's the preferred approach. And we've seen in the last 20 or so years kind of a renaissance of libertarian and conservative legal theorizing about the original meaning and limits of the Constitution, and making the case that if a judge finds in good faith that a law is incompatible with the Constitution, they shouldn't have any hesitancy in striking it down. Turning to this particular law, the majority of Professor Siegel's remarks were about the Commerce Clause. And when I started working on this case, I sort of assumed as well it was going to be a Commerce Clause case. That was what a lot of the debate was about at the district court level. So it's an interesting first question of strategy by the government's part, because now on appeal at the Fifth Circuit, the government is pretty much dropping the Commerce Clause aspect of the case and is focusing entirely on the taxing power. And I don't know whether, just as a strategic matter, they're concerned that this could go up to the Supreme Court and we could get a presidential decision that that moves Commerce Clause jurisprudence in a way that's more restrictive of federal power. It's a really interesting question. But the case as presented now by the parties, but the case presented by their arguments focuses solely on, is this law justified by the taxing power? And if we focus on that issue, I think the government's argument is pretty implausible and I would say pretextual, because essentially their argument is, if you we have a tax on producing liquor, everyone who produces it needs to pay the tax. If you produce it at home, it's a lot more likely you could evade the tax. It's hard. How is the inspector going to know what you're producing at home? Okay, fair point. But does that allow the federal government to then say that it's a necessary and proper exercise of the taxing power to simply ban the activity entirely? In other words, if it's too hard to find the taxable activity, we can simply ban it because it would be too likely that the taxes would otherwise be evaded. And I think if you just think about the scope or the implications of that argument, it's pretty shocking. You could essentially imagine any type of activity that the federal government can legitimately tax and then say, okay, we can now ban this activity if it's produced entirely within a home or entirely within what you might call a discrete sort of economy, where you don't need to put it out in the broader marketplace where it would be evident if you're committing tax evasion. So Cato Institute also filed an amicus brief, also supporting the challengers to the law in this case. And we focused on the implausibility of this textual argument. We also focused specifically on rebutting the Supreme Court case that the government is relying on most heavily. And that was a case called Felsenheld. And that was a case about producing tobacco pouches. And essentially, some companies had been putting prizes in the tobacco pouches, but that was affecting the weight. So there's a tax, you taxed the tobacco pouches based on weighing them, presuming that the weight told you how much tobacco was in it. But if they put a prize or a toy or something else in there, it messed up the weighing aspect. And so the government said, we're simply going to ban putting these prizes or toys in the bags entirely. The Supreme Court upheld it, saying it would be too hard to determine how much tobacco is in it. So that's probably the government's best case, but it's important to stress that doesn't go nearly as far as this case would. That didn't go nearly as far as completely banning the production of the good in a certain circumstance, a good that's otherwise legal. And I think, to me, in this case, there are kind of echoes of the major questions doctrine, in that you kind of have a statutory hook, or in this case, a constitutional hook, the taxing power, that is being used not to, in fact, take in a tax, but to achieve some other policy goal. The actual policy goal is preventing at-home distillery, and the government, now that they have to justify or defend it, found the taxing power and has kind of built this legal argument around it. So I would say that a good faith reading of the Constitution shouldn't allow the government to pick and choose or sort of find something to hang its hook on. We should be skeptical just by the fact that the argument has shifted from the Commerce Clause to the taxing power. I think that should make us skeptical that the taxing power is a plausible hook. And I think we should be really concerned if that argument were accepted, what other activities within the privacy of one's home would the government suddenly be able to ban? And I'll stop there.
Can I respond to one thing Tommy said? Just one thing?
Sure.
Yeah.
I was about going to do a round robin again, let everybody respond. But
Okay.
Go ahead.
Already you volunteered.
Thanks. Sorry. I just want to say because you said something really important, super important. Thumbs on this, what judges should do about putting thumbs on the scale. I just hope Tommy recognizes that if you're saying, as Michael Rappaport and others say, that judges should look at a federal or state statute and say 51%, 49% unconstitutional, therefore I'm going to strike it down, or something like that. That's fine if you're a living constitutionalist to the nth degree. The original meaning of judicial review, the original meaning of Article 3 was enunciated by Alexander Hamilton, the person, not the actor, in Federalist number 78, when he said judges would only strike down laws when they're in irreconcilable variance with the Constitution. That means a clear inconsistency, absolutely no way to harmonize the two. That was the Federalist Society's motto in 1982. I think that's how this country should be governed. Leaving aside the merits, judges should only strike down laws if it's really, really clearly unconstitutional. So I'm curious if the panel thinks this law is clearly unconstitutional under that standard, or if not, are they willing to don the mantle of living constitutionalists? Because you're not an originalist if you don't put a heavy thumb on the scale of constitutionality.
Since it was in response to me, I'll take a first crack at it. I guess I'd say first, I'm not 100% sure. I would have to dig into interpretations of that particular quote by Hamilton. It seems to me, as my first reading of that is that it's describing what does the judge come to a conclusion about? Is it irreconcilable or not? And that maybe is different from how certain are you? In other words, I would say, I guess there are two ways of thinking about judging. There's the uncertainty way of thinking about it, where a judge sort of admits I'm only 51-49, or there's a way of thinking about it where every judgment is simply based on you have to come to a conclusion, you have to reach something, you have to do your best and keep thinking about it until you hit the answer that you're going to hit, that you think with, and then you just have to let the chips fall where they may based on that. So I think I tend to think of the judicial role as more the latter. And even if it's 51-49, you end up getting to a point where 51 is what you're going with. And then you ask, okay, the interpretation I have, is that incompatible with the Constitution? So I think the quote that was just read, which I'll have to go look up, I think could be compatible with that approach. But I know Professor Siegel obviously disagrees.
I mean, it's a whole history of 25 people saying that, but that's okay. We can move on. It's not just Hamilton. They all thought that. Everyone who talked about it thought that. Every single person. There's no person in 1791 who thought the judges would play anything other than a very limited role in constitutional law. That you won't find a single voice.
You're speaking basically of just limiting themselves to the present case and controversy and the parties before them.
No, what I'm saying is they talked about and thought about in the prisoners' cases, for example, what do we do when a state or federal law is inconsistent with either a state charter or the federal or a constitution of some kind? And Randolph talked about it. All the founding fathers talked about it. And what they said was, this only works if judicial review is modest, deferential. No way it's 51-49. There is no interpretation of any historical source that suggests it's 51-49. It was supposed to be modest and limited, and that's what the Federalist Society said in 1982.
Well, let me turn now to Michael Pepsin and then let him either respond to these specific comments in this thread or anything more generally that the other two speakers have said that he'd like to address.
I suppose just a couple quick reactions. One, some might say maybe it is the judges or justices' role to say what the law is, but as constrained by the concrete cases and controversies and precedent, where perhaps in this instance, as the district court did and confined relief to the actual parties, applied binding precedent, but also cognizant of the background original public meaning of the Constitution. And another couple just very quick notes. I would submit it's important if we're going to be serious about original public meaning or textualism to not be fair weather about it. The same would hold true as to federalism. And I suppose this loop back to my first thought. Just last term in the Supreme Court in Loper Bright said, you might have ambiguous laws, but it's the judge's job to, find it has a single best meaning fixed at the time of enactment. And finally, I might very briefly note as to the taxing power, there was actually a case United States v. DeWitt decided in, I believe it was 1869, where the Supreme Court found that a statute that banned combination of certain oils for sale. I don't know the whole background of that because it allegedly increased the price of other oils that were more favored. It rejected the government's argument that that was sufficiently tied to the revenue raising function of the taxing power to pass constitutional muster. So I do wonder where it's and finally, with that statute at issue, it's 100+ years out from the Commerce Clause, I would submit. So it's sort of, yes, it's old, but I'm just tentatively wondering how much that matters. But thank you.
All right, well, to resume our original order, Professor Siegel, is there anything further you'd like to say about the other two speakers before we move along?
I agree with them that the tax arguments are troubling at best, and I wish we didn't have to use them. Why the federal government changed litigation strategy, I don't know. There could be all kinds of things behind that having nothing to do with the merit, as everyone knows. That could be strategic for all kinds of reasons, having nothing to do with constitutional law. I would just say, I think our country would be a better place. Clark Nelly and I are really good friends. Clark and I have debated like 10 times. We've broken bread together on many occasions. I think Clark does many great things in the space of qualified immunity and other places. Clark and I have debated originalism, but it always ends up with Clark admitting he hasn't really studied. I don't think Cato has really studied originals. I have. And I am telling you that judicial engagement, I've written 3 articles on this, 2 books. Judicial engagement might be a good thing or might be a bad thing. I'm not going to have the policy argument today. But as an original meaning thing, it is absurd. It is absolutely absurd. And everyone in 1982 knew that. Like Judge Bork knew that. Everybody knew that. So the one point I want to make is the only reason this case is really here today in a serious way is because Ronald Reagan and George Bush appointed 12 years of judges from 1980 to 1992. And then Randy Barnett, Keith Whittington, and Larry Solomon wrote a bunch of articles that basically changed originalism from a theory of constraint and restraint to a theory of activism, because Randy is above all else a libertarian. That's fine. And when I reviewed his book, I said, I have no issue with his vision. I don't know. I could be right, it could be wrong, but there's nothing con law about it. So I just want to say again, if you believe in originalism in any way, shape, or form, then these laws don't get struck down. They can only get struck down under a living constitutionalist approach, which might be the best one. I'm not, in other words, but I am on record as a deferentialist. I am as on record as saying you have to be absolutely certain. And Tommy, the last thing I would say is this: the 51. It may be that if you're 51-49% sure there's an irreconcilable variance, that's fine. But the key there is irreconcilable variance. Is there any way to reckon? And Justice Roberts has in the past paid lip service to this too. Only lip service, but he's paid lip service to it. If a judge can find a way to reconcile a statute with the Constitution, she is supposed to. And that's the original meaning of the judicial review. And that's not debatable. It's just not fairly debatable. So if you want to change that, that's fine, because I'm not an originalist. Just say it's better to have judges playing these active roles, and that's fine. Just don't pretend it's originalism, because it's not.
Okay, Tom, you're third in the order. What else would you like to respond to or talk further about?
Just one point, and this is, I know no one on this panel's views are going to be changed. So even though I'm responding to Eric, I'm really more making points for interested viewers if they want to follow this debate, which I think is the debate of modern constitutional law. So it's great that we're maybe introducing viewers to it. If they want to really dig deep into some of the debates around originalism, I'd encourage them to dig into what Randy Barnett and others have called, and Larry Solomon have called, the distinction between kind of the original meaning and then the construction zone or application of original text or original meaning, and the notion that we are bound by the text itself, the original public meaning of text, but we're not necessarily bound by the original application or the original beliefs about how that text would be applied. So to give one classic example that's often used for school segregation, Brown versus Board of Education, equality had a fixed definite meaning in the Equal Protection Clause in the 1860s. But if people at the time had the false belief that racial segregation in schools was compatible with equality, we're not bound by that original understanding. That's kind of the distinction. So future knowledge, future growth, realizing that segregation is incompatible with equality, that can still be originalism. And so I would say that one avenue for people studying this to think about is, we're certainly bound by the text of the Constitution, that we have a judiciary, the supremacy clause. But what aspects, even if I sort of spot, Eric, some notions that some of the founders had a more restrained vision of how often would judges strike things down, are we bound by their original expected application of the constitutional text? And I would say we're not, that originalism can in fact be consistent with not agreeing with how particular founding fathers thought the text would cash out or the text should be applied.
Well, I have to respond. I'm sorry, because I wrote an entire book on that point, basically. Listen, if you say that we know what the expected application was of imprecise text, we know what it was, but we're going to discard it because facts and values have changed. Yes, that's exactly how con law is done in this country. It's exactly how the Roberts Court does it, but it's not originalism in any sense. We know what they expected, and we're discarding it because values have changed. In any case from 1791 text or 1868 text, there's going to be changes in society that can justify. This is how Steve Calabresi, the freaking co-founder of the Federalist Society, said same-sex marriage could be justified on an originalist basis. That's obscene. That's absurd. I mean, I'm for same-sex marriage, but of course no one in 1868 thought that. So what he said was, yeah, it stands for equality, and that's really undefinable, and we define it differently today. Yes, I agree. I agree. That's living constitutionalism. Originalism would say, did they think about this issue, and did they decide it? And Randy Barnett in 1994 says, even if they did that, we can ignore it. Why is Randy saying that in 1994? Why is Larry saying that? Because they just had 12 years of judges, and now they get to control the power. Randy Barnett never says that in 1979 or 1983. There's not a chance, because liberals controlled the judiciary. Last point. When you say judges can discard known expected applications of imprecise text, you are saying they can be living constitutionalists, because there's no such thing as the fixed meaning of imprecise text. The word tall, pretty, smart, handsome, big, equal, exercise, establishment, unreasonable, and cruel don't have fixed meanings. They only have applications. Done lecturing, sorry.
Okay, I'd like to continue with a couple of questions for the panel. We've noted that the Commerce Clause was originally a pretty big part of the argument, and that the government chose to drop it. I understand there is a parallel case pending in one of the federal district courts in Ohio, where it is still under consideration. Is anyone aware of that, or have you had any opportunity to look at that and just add that to the mix for comparison's sake?
Absolutely. And if I might, the case is, I believe, Ream v. United States. And the government was defending on Commerce Clause grounds, but I believe last week the district court, and in my view, I'm kind of skeptic, or I'm sure that it will be appealed, but dismissed it for lack of standing without reaching the Commerce Clause arguments. So now I would imagine it will go to the Sixth Circuit, where some of their cases, such as United States v. Rife, take a fairly absent binding precedent to the contrary. The Constitution's original public meaning is law, and it will be very interesting to see how that plays out.
What's fun
Anybody
about
else want to
that
comment
is
on that? Go
everything.
ahead.
I'm sorry. What's fun about that is everything about standing is also non-originalist. Strangers to the court were allowed in England. What's his name? Sorry, I'm having a senior moment. The guy who wrote Governed by the Raul Berger wrote in 1968, the most famous academic originalist in history, wrote in 1968 that anything involving personal injuries is a made-up living constitutionalist thing, that of course they can, and Justice Harlan and Flass says personal injury is not a constitutional requirement. It's something we should look at in our discretion. I just want to say everything about standing is also not original.
Well, standing is a pretty big part of the posture of the case. If you look to see that it's complicated in a lot of cross appeals and cross replies, because the plaintiffs were an aggregate number of individuals as well as an associational plaintiff. The district court held there was standing for one plaintiff, Mr. Scott McNutt, dismissed the others for lack of standing, but then by virtue of that one plaintiff found associational standing. And so there have been cross appeals by those dismissed individual plaintiffs, and that came up in the briefing as well. Does anyone want to address that? And particularly, I think it comes down to, in my view, the question of applied versus facial challenges. And does that make any difference to what we've been discussing here today.
Standing is what standing does. I wrote that in the LA Times. It's true. If they want to reach the merits, they will, and if they won't, they won't. And does anyone in the panel disagree with that? That's true for all of jurisdiction. If they want to hear the case, they will. If they don't want to hear the case, they
I would
Mike or Thomas, who wants to go first?
I'm 30% less cynical than Eric. I think 30% of the time they will rule on standing in the opposite way that they want to, if there's no way not to. But I won't deny that some motivated reasoning comes into play. In terms of this particular case, it seems to be kind of a fact-bound question about, did McNutt, this one plaintiff who was found outstanding, was he in fact distilling in a prohibited space, or was the shed he was distilling in separate enough from his house to be legal, or does he have concrete enough plans to distill in his own house? It gets complicated. The broader point I'll make is that I think one of the frustrating things about standing is it puts a lot of individuals in impossible positions where the government says you need to violate the law or come extremely close to doing it, put yourself at risk of fines or criminal penalties, then you'll have clear standing to challenge it. Up until you get to that line, you don't. And it kind of puts people in an impossible position. So I'm always frustrated when the government makes that kind of argument.
Common ground, I agree. And if one was an originalist on standing, one would say all there needs to be are two adverse parties arguing about something real. Will something real happen in the world if this case goes and all these two parties truly adverse? That is the original meaning of case for controversy in Article 3, but Justice Scalia basically took that meaning away.
Michael, did you want to comment on this point?
I would just submit, I agree with what Tommy said as well, but I also would submit, if the party has standing, the court should decide it as a normative matter and should not duck the merits, regardless of whether it's the issue is controversial or regardless of, his or her policy views.
We agree. Common ground.
With regard to standing, you note that a lot of the precedents about whether or not you truly have been harmed or a threat of enforcement often arise out of the First Amendment's free speech context. Do you think those are equally applicable if we're dealing with something more quibbling like taxes and whether you're in a shed or an attached dwelling house?
Now that's interesting. Before 2 weeks ago, I would have said no, and now I've changed my mind. Just in 2 weeks.
Why is that?
So this is going to get serious. I'm sorry. And the last week I've talked.
Because the rest of this is not serious, Eric.
No, this one's more serious. I talked to Bloomberg, CNN, and Georgia Public Radio all in the last week. And all 3 times I censored myself. I did. And I've never censored myself before. 34 years of being a controversial law professor. I've never censored myself until the last few weeks. I now, for the first time in my, I used to criticize the overbreadth, chilling effect doctrine of third-party standing in free speech cases. I no longer do, because I felt the chill. And it is horrific to feel that chill.
So does that necessarily extend beyond the speech context to these other issues such as taxation and distillery within your home?
I'll let somebody else take that.
Yeah.
I think it should. I don't think it does under current doctrine. The Supreme Court has given free speech probably free speech and equal protection. It's given the most weight to, or however you want to put it, the most protection to. And in my view, it's made a lot of other constitutional rights kind of second class in a way that they shouldn't be. All the logic of chilling effect applies just as well to any other freedom protected by the Constitution. But for a lot of reasons, I guess the simplest just being that it's so explicitly there in the Constitution, freedom of speech, the Supreme Court has built up a much more robust doctrine of protecting people even before enforcement there than it has in pretty much any other realm I can think of.
Michael, your chance if you want to weigh in on this.
I would submit you shouldn't have to bet the farm or risk prison to get your day in court.
But by the way, not only do all 3 of us feel that way, more importantly, the United States Congress feels that way, because that's the whole purpose of the 1936 Declaratory Judgment Act. Congress specifically said, and it makes so much sense, we want people not to violate the law. We want people to be ready, willing, and able to violate the law, but not do it until they get a court declaration saying they can. Of course, they can't change Article 3, but if you take my originalist interpretation of Article 3, which I think is the correct one, which is you need 2 adverse parties arguing over something real, that's what the 1936 Congress thought. And I think the Declaratory Judgment Act totally is a federal statement, very strong on this policy. File suit before you violate the law. And judges should be amenable to that, as long as the plaintiff, obviously, we all would agree on this too. You know, you have to be ready, willing, and able to break the law, right? But assuming that's true, court should hear the case. I love getting common ground.
We have any other further comments so far? I'm going to turn soon now to picking and choosing, exercising my prerogative from the viewers' questions and Q&A submitted questions. It's been a few minutes since this was posted, but one viewer asked, what is Professor Siegel's thoughts on the tax power argument the government made? Have you addressed that already?
I'll just say Professor Siegel has not studied tax constitutional law enough to have what I would have a public opinion on that statement. I don't teach tax law. Of course, I got into it with NFIB. I tend not to try to talk about things I'm not an expert about, but my instinct is it's very questionable as a tax law.
Another interesting point raised is, does the panel see this case as having any relationship to dormant Commerce Clause challenges to state regulation of alcohol regulation or implications of the 21st Amendment?
Well, I was going to ask Cato about that. Why didn't you guys bring a 21st Amendment challenge here?
It's not our lawsuit.
Well, I mean, you an amicus brief, though. I mean, you could. I mean, you know.
Interesting. 20.
Listen, after Dobbs, we know that the question presented thing is a myth. The Supreme Court will decide whatever it wants to decide. So any offshoot, remember, Dobbs being overruled was absolutely not part of the question presented in that case. So anything that's fairly, you know, raised. And I think the 21st Amendment argument here is interesting. I'm wondering why it wasn't raised.
What? Say more about what that argument would look like.
Well, I think the state has the authority to regulate taxes in and out, I mean, alcohol in and out of its state. In its state, I know the Dormant Commerce Clause case about this, but this feels like an invasion of state prerogatives, especially because I think, doesn't Texas law prohibit this already? Maybe.
Yeah, I'm not an expert on that. I will say that this may shock you, but even though I would like the Dormant Commerce Clause as a policy matter, I'm not convinced that it's a thing as an originalist matter, and so I've been skeptical of making those arguments. Cato hasn't filed a pro-Dormant Commerce Clause claim amicus brief in several years, and so similarly, I guess the question would be: should you interpret the 21st Amendment to implicitly say there's no that it's only a state power? I don't have the exact text of it in front of me. It says the states can regulate alcohol, but should that implicitly mean the federal government doesn't get to regulate alcohol?
Doesn't it go to the essentially, strictly speaking, where the Fifth Circuit is before it, the issue of just how far is too far with the exercise of the federal taxing power? So can we then invoke the 21st Amendment as coupled maybe with the 10th Amendment to say this is an outer limit on what the taxing power can reach?
I don't think that's frivolous. I mean, I don't know. I mean, the text of the amendment is the Prohibition Amendment repealing it is so bizarre and crazy and all that. My guess is, I don't know. I think that there must have been a strategic reason not to raise it. I don't know what it is. Like maybe the Dormant Commerce Clause case that rejected it takes priority. I don't know.
If viewers are interested, Eric's favorite law professor, Randy Barnett, has an article coming out about the party presentation principle, which I agree courts are very inconsistent about. This is basically the question of to what extent can they consider arguments raised by amicus briefs, not raised by the main parties, which is very important to my line of work since I only file amicus briefs.
Well, you should know that it's exactly the same rule as standing. It's exactly the same. If we want to hear the case, we'll read it. And if we want to resolve the issue, we will. And if we don't, we won't. And if we don't want to, we don't. I mean, I'm very serious about Dobbs. No one talks about it, but it was not in the question presented. Reversing Roe case.
Is this akin to the idea that if a court doesn't want to deal with the issue, they'll just find some way to say that the plaintiff had the appellant had forfeited or waived the issue in the earlier brief?
Yes. By the way, no one in this panel can tell me what dig means. And last term, the court digged a big abortion case. We don't know how many justices it takes. We don't know what criteria they use. It's not even in their rule. There's no written rule about digs in any Supreme Court document that's external to the world. So yeah, in all of these jurisdictional issues, it's always the same. I mean, they'll hear it if they want to, and they won't if they don't. I don't have to be a crazy legal realist to understand that. Just look at the case law. Look at the Duke Power case when it comes to standing. That case is completely absurd, and there's 25 others like it.
For the viewers, dig is dismissed as improvidently granted. That's where the Supreme Court agrees to take up a case, grants certiorari, and then dismisses the case without ruling on the merits. Says, "Oops, we changed our minds. We wish we hadn't taken this case."
But there's a big debate with how many justices that takes, because 5 can undo 4. If 4 justices grant cert, but 5 dig it, then the 4 for cert doesn't matter. So Justice Stevens said once in a footnote, it should have to take 6 judges to dig. Well, think about it. If 5 can dig, the rule of 4 makes no sense, because 5 can just dig every 4 case. But again, there's no rules about that because the Supreme Court doesn't believe in transparency.
For viewers at home, it takes 4 votes to grant certiorari. We know that rule at least.
Tom, can you just accompany me everywhere and translate my word? I know you're really good at it. I'd really appreciate it. It's
This is
awesome.
why we have multiple panelists.
He's doing
We
great.
haven't heard from you in a little while. Is there anything you'd like to add or take along these threads?
Well, I learned something every day about the dig issue. I did not know there was like no procedure about that. And I would just say more broadly at a 30,000 foot level of the nature of the originalism debate, I think to myself, leaving aside the judicial review piece of this, it seems to me that there's some smart people persuasively, in my view, argue that the Commerce Clause originally, the word commerce meant, trade and transportation, not manufacture and agriculture, and, is meant for, interstate interactions. And, it was expanded, I would submit, the precedent like Wickard obviously was in the, New Deal era where he had Great Depression, World War II, et cetera. And I wonder if there's validity to what I'm suggesting, and if there's any validity to the folks who argue for a narrower conception of necessary and proper, why didn't we, maybe it's too hard or what have you, but where does Article 5 in the amendment process play a role in this? I'm not expressing.
Michael, in 1823, the Supreme Court of the United States in 1823 said that it basically, Commerce Clause reaches all commerce that affects more states than one. It didn't say affects more states than one. So, yes, I understand that Randy and Larry and some other people think they know what the original meaning of the Constitution is better than John Marshall. I get that. But everyone you're talking about, those smart, persuasive people you're talking about who make those arguments, their argument is that John Marshall didn't have the Constitution right, that John Marshall was a nationalist, which he was, of course, and took a more robust view of congressional power than the original public meaning at the time. But if we're going to discard what the Supreme Court said unanimously in 1823 or whatever it was, because some scholars in 1995 think they know better, I think we need to take a step back. In addition, this law passed by Congress much closer in time than Randy Barnett writing in the 1990s. Listen, I wish Cato would, Ilya Shapiro and I have argued about this so many times. Just come out and say you want a libertarian society, you want deregulation, you think our world's a better place with that, and judges should enforce that. And I'm not going to argue with you. I might argue on the merits, but I can't say you're wrong about that. But stop calling yourselves originalists, because there's nothing in originalism that supports you. There's just nothing, and all of Supreme Court history suggests that, except for a couple outlier cases during the Lochner era, like the child labor case, which, by the way, caused tens of thousands of children to work in mines under terrible conditions for 3 decades longer than they should. So again, healthy debate. What should Congress's powers be? Healthy debate, and maybe they've gone way too far. Healthy debate. It's not an originalist debate, and we should stop putting it in those terms.
But let me turn it a little bit back more to the formalist aspect of the case and particular issues. We've mentioned that the standing issue and the whole issue question of whether or not McNutt or the other plaintiffs were sufficiently endangered or threatened with government action. And I know in the briefs it went back and forth a bit about who received a letter or a notice from which agency, and who would just know through their associational context that at least one of them had received notice and so forth. I noted that the government's reply brief seemed to get down in the weeds in that regard and started quibbling, as I think one of the panelists referred to, about what is and isn't at home, and did you really say you're going to at home? I know when I read that brief, I was struck by, well, would the government accept that as a defense if they were in fact to prosecute someone, say, well, it's not really a home, it's really somebody. And I just wonder, given if we want to be a more realpolitik here today, given the known composition and the current track record, if you will, of the Fifth Circuit Court of Appeals, do you really see this court going into the weeds there on what is and isn't at home, or who does and doesn't have standing? Where do you think this is going to go?
Well, they don't have to get into the weeds on the merits, because I guess the Commerce Clause issue is no longer in the case, which is really weird to me.
But
Getting into
the question of the taxation enforcement of the tax laws, and that really is what at issue is. How far can you reach to tax something, or to go beyond just taxing something and go into the intrinsic nature and origin and production of what it is you deem to tax?
It's not a tax.
And Justice Roberts is heard from again, right?
It's just not a tax. Neither was the mandate. Neither one's a tax.
More panel agreement. Great.
You can't on that, just for the listeners, maybe if the alcohol thing is interesting enough. When Justice Roberts upheld the Affordable Care Act, calling that thing a tax, one of the real problems, and this case too, I think, same thing, is that when the President of the United States goes around the country and says it's not a tax, when the Congress says it's not a tax, when Democrats are lobbying in town halls saying it's not a tax, the court should not call it a tax. That's my personal opinion.
Has anyone noticed whether or not the spirits industry, the alcohol industry, they seem to be silent here? They haven't weighed in or filed an amicus that I'm aware of.
Mm. Well, it may be literally a bootleggers and Baptists kind of scenario here.
The industry is going to be for this law, right? They don't want homemade. They don't want homemade stills.
But certainly.
Yeah. And by the way, that's part of that. If you really want to get into Cato's agenda, that's the problem right there. So what Clark and I have discussed many times is Clark thinks rent seeking is unconstitutional. I'm assuming everyone on this panel thinks that as well. That one part of the economics of our society shouldn't be allowed to get a law passed to favor them and exclude others. That's what this is really about. And my response to that has always been, I don't like the rational basis test. It's wrong. It's misleading. I agree with Clark about that. But giving judges the power to distinguish rent seeking from legitimate regulatory behavior is just too much power for judges. As a Commerce Clause case, this case is easy to me. As a tax case, it's hard.
Well, gentlemen, I think we've reached a point where it's appropriate to give everybody a closing statement. Should we stay in the same order and go, but Michael Pepsin?
Well, I suppose I would just say at a 30,000 foot level, I do think this case raises, important, methodological questions, as well as interesting practical ones of what would the world look like if, the plaintiffs win here and the federal government can't reach this conduct. Maybe the federal government, I would submit, shouldn't be regulating things such as, everything from, on the one hand, a locality wants to ban gas leaf blowers. On the other hand, a locality wants to, legalize or prohibit marijuana, such as what was at issue in Raish, or home distilling, such as the case may be. And I know that might sound more in policy, if you will. And also, I suppose my closing thought is, I do wonder if, as a methodology, if we can at least, follow originalism where it leads, and people would, take issue with what I'm saying, and, different professors will disagree, and maybe you get to a world where maybe you do need an Article 5 amendment or two to modernize, but is it better to stick with what was intended, and is that this? Thank you.
Well, what was intended was to give Congress the power to regulate commerce among the states. What that meant in 1791 is very different than what it means today, as Tommy was saying earlier. Whatever they thought in the micro, in kind of the small sense, in the big sense, give James Madison all the information about the interconnected international and domestic economies we have, and James Madison, and they all would say Congress can do this because we need one unifying national institution when we have this kind of interconnectedness. But the main thing I want to say real quickly is I think that as a matter of real politics, the Supreme Court is going to find a way to decide this issue on the Commerce Clause basis. I understand it's not in the Fifth Circuit. They're going to find a way, and they're going to use it to overturn Raich. Just as Justice Kennedy came to the Supreme Court wanting to overturn Bowers, which he did, just like Justice Alito had wanted to overturn Janus for decades, this court wants to overturn Raich at this point. And this case would be the exact, and maybe even Wickard, maybe Wickard, but I doubt it, but definitely Raich. And they're going to, and if this case follows a certain route, they'll find a way to signal to the people bringing this case to the Supreme Court that put the Commerce Clause back in because they want to reverse Raich, and that's what's going to happen. And then Randy can go out for dinner and celebrate.
I'll just a couple comments. So I'll serve as translator again. Randy Barnett argued Raich for
Thank you, Tommy.
people who don't know. Read Randy's excellent recent autobiography if you want to hear the story of how that case came about. It's pretty fascinating and how he got to argue it. I agree with Randy and others that it was a massive expansion and an unfortunate expansion of the federal government's powers. It said the federal government could regulate medical marijuana grown in one's own house for one's own personal consumption. And I agree that that case was influenced, unfortunately, by the justice's skepticism, Justice Scalia in particular, of the plant at issue, the drug at issue. And liquor is more traditional, perhaps has more of a history in the United States than medical marijuana, and so might be easier for stodgy older judges to accept that as a good test case for the limits of the Commerce Clause. The last thing I'll just say about judicial review, since we had a lot of back and forth, I'm not going to convince Eric, but for any people watching, I agree judges are not great necessarily at reading minds, at telling what someone's intent was or whether they were in bad faith. I would say that to paraphrase what people have said about other systems, they're the worst people in the system to judge that, except for everyone else. And so someone has to do it. And that's why I think federal judges are the ones who have to do it. And it's important that someone in the system serves as a check against bad faith efforts by the government to protect entrenched industries.
All right, then. I'll give everybody one last chance if you'd like to weigh in again.
I'll just say what Tommy just said is exactly what my students 10 years ago thought Raich was correct. No student in my class this year thought Raich was correct. There has been a sea change in how at least my law students view congressional power. And it's much more along the lines Tommy is talking about than the way I've traditionally seen.
Right. Tommy or Michael, anything else?
End on a note of optimism. That's great.
Or pessimism, depending on where one sits.
All right, then. Well, with that, we'll wrap things up and conclude, and thankfully hand over to Edith for our outro.
Yeah, on behalf of the Federalist Society, I'd just like to thank Thomas, Michael, and Professor Siegel for speaking with us today, and Ted for moderating. We're so grateful for your time and expertise. And thank you also to our audience for joining us. We really appreciate your participation. You can stay up to date with announcements and upcoming webinars on our website, fedsoc.org, or on all major social media platforms. Thank you once more for tuning in, and we are adjourned.